Roll for us.
Davenport. Lee.
Here.
Miller.
Here.
Wright.
Present.
Fisher. Here. Johnson. Culpepper.
Here.
Myers.
Here.
Thornton.
Here.
Hamby.
Here.
We have a quorum.
All right, thank you, Sarah. I really appreciate it. The purpose of our meeting tonight is to consider an appeal of historic preservation decision regarding Certificate of Appropriateness COA 2025-02-0342, which is 120 West Cloverhurst Avenue. And there are unique opportunities for public input for a meeting of this sort, which we don't do very frequently. So I want to go over the procedures. First, the party who filed the appeal may present a 10-minute argument in support of the appeal, and opponents may then present their 10-minute argument. Neither side is required to use all of the 10 minutes. Either side may allocate its 10 minutes among any number of speakers, provided that the presentation by all speakers for each side shall not exceed 10 minutes. All persons wishing to speak during one side's 10-minute argument must register their intent to do so, which they have done in a sheet in front of me. And in the event that all persons wishing to speak as part of one side's 10-minute argument are not able to agree how that side's 10-minute argument shall be allocated, they shall inform the mayor of their disagreement, and I get to determine how that time is distributed. And then after the opponents of the appeal have concluded their 10-minute arguments, the party who filed the appeal shall have a 3-minute rebuttal. Okay, so as a proponent, we have just a single signatory, and that's Jeffrey DeLoach on behalf of the property owner. So, Mr. DeLoach, good to see you, and Sarah's going to begin the timer, so your 10 minutes begins now. Good to see you.
Thank you, Mr. Mayor and members of the commission. I appreciate the opportunity to be here. I am here representing Mr. Williams and David Matheny, who is the applicant for Mr. Williams at his home at 120 West Cloverhurst. You all have been provided the materials that the planning department put together for you with respect to this appeal, and so I'm just going to try to jump in here. This is a situation where we are appealing the denial by the Historic Preservation Commission of a application for certificate of appropriateness. This deals with a garage that is being constructed at the rear of the home at 120 West Cloverhurst that is replacing a previously existing garage, and it does have living space above the garage. There was a plan approved previously for this, and it was for this garage, and it was permitted, and construction began in October of 2024. Substantial part of the construction was completed. The planning department received a complaint, and they performed a site visit, and they alerted Mr. Williams and the applicant that there was an apparent discrepancy between the approved height of the garage and the height as constructed. Mr. Williams voluntarily stopped work right then to investigate, and did in fact investigate, and prepared a survey, an actual elevation survey. And real quickly, elevation, just how many feet above sea level, height, difference between ground and the roof. And so obviously that's addressed in the letter that we provided to you. The only thing on the original approved plans is a height difference between the ground and the upper part of the roof, and it is on the north side of the garage on the plans, and the plans show 21 feet at that point. It turns out the way the elevation runs the house, it goes uphill from the house to that part of the property where the garage is. So as it goes uphill, that back corner, it actually ended up being 21.7 feet tall at that point. So it's 0.7 feet higher than what's shown on that plans. What surprised, frankly, Mr. Williams and the planning department was that ultimately, with that 21.7 feet height, it was 4 feet higher elevation-wise than the main home. And so that's really what brought us here, is once this construction was done, based on some decisions that were made during construction by the contractor, that we're here readily acknowledging that the elevation is 4 feet higher than the main home. And there was a belief that that is a divergence from the original approved plan. So we applied for this additional approval by the HPC for certificate of appropriateness, and also addressed two other things that, well, really three, I guess, other things. One is a slight widening of a walkway and a brick, I'll just call it siding, but a brick up the side of the building, the garage, kind of as a design feature. And then there's also a retaining wall, which became necessary. Those things were all part of this certificate of appropriateness request that came before the HPC. And we're here asserting that the HPC abused its discretion in denying that. And just to get to what happened at the HPC's decision appeared to be driven by belief that Mr. Williams just ignored the previous approved plans, and they were upset that he appeared to ignore that. And that was, in fact, not at all his intent, and that was stated in the hearing very clearly. Mr. Matheny said that was not his intent. There was some some construction decisions that were made that were explained, and we're here to try to, now that it's built or almost built, to get appropriate approval for these things. And we think it is designed in a way that it should be approved. And in fact, Professor James K. Reap spoke in favor of the application. He was the only expert. He explained his 40 years at UGA as a professor, serving on 3 preservation commissions, including the Athens-Clarke County HPC, and having trained preservation commissions in more than 30 locations. And all of this is in your materials, but in short, he said he believed the revised application should be approved as submitted, and he said, in his professional opinion, having reviewed many COAs, this construction does not cause a substantial adverse effect and should be approved as submitted. Denial would, in my view, impose an undue hardship on the property. That was the testimony of the only person who was there with expertise in historic preservation. And then what happened is the HPC started discussing it. They did not discuss, and this is important, they did not discuss the brick retaining wall. They did not discuss the width of the breezeway. They did not discuss the brick featured on the walls constructed. None of that was addressed at all. You have the transcript. There was no discussion. There were no standards applied. It just wasn't discussed. It became apparent when you read the transcript that they were focused on the fact that Mr. Williams allowed the garage to be constructed in a manner that deviated from those original plans that were approved. And so they denied the application without, in our belief, we believe it's clear, they did not apply any set standards to it. And as a result of that, that's why we're here. That's why we filed this appeal. That's why this hearing is available to us. And that's why you are here to sit, to hear it. Again, you all can read my letter, and I know have been in front of you before. I know how diligent you are. I know you are prepared. So I don't want to go on and on. But I will say that the Georgia statute makes it clear about when an HPC, it says the HPC must approve an application if it finds the proposed material change in appearance would not have a substantial adverse effect on aesthetic, historical, and architectural significance and the value of the historic property or district. And then it sets out what is supposed to be considered to do that. And that's what Professor Reap spoke to, and that's what's in the transcript that you have. And he addressed that directly and said exactly what the statute says. There is no substantial adverse effect on the aesthetic, historic, architectural significance, and therefore, the HPC, you should approve this application as it was submitted. So we're here on abuse of discretion standard. You have very good counsel who certainly can explain that, but we are to show that it was arbitrary, capricious, or unsupported by the evidence. In fact, we believe it was arbitrary and unsupported by the evidence. First, because there was no evidence or discussion of the short brick wall, of the wider breezeway, or of using the brick up to the height of the window sills. And also, there was no evidence that the features, including the height, was in fact a substantial adverse effect on this neighborhood. And that goes back to the heights that I've talked about in the letter. And it's important to know from an elevation, so again, above ground level, the main house is at 751. This garage is at 752. The neighbor, Mr. and Ms. Totten's house, right next to them, the roof peak of that, 672. So again, well above our garage. So it's not like we're towering over anything. The second neighbor, roof peak 773, 20 feet above the roof of this garage. Again, this garage is not towering over its neighboring properties. And so all of that is the evidence that supports what Professor Reap described about this neighborhood and about why he believed that the architectural variety in the neighborhood was a distinct part of the neighborhood's historic character, in that this structure remained in keeping with the district established patterns. That's what he said, and we believe that is the evidence that was before the HPC, and that in fact, therefore, what they did was abuse of discretion. So what we're here asking you to do is within your rights under both the statute and the procedure, and that is that you should reject the determination of the HPC and grant the application for the certificate of appropriateness as provided for in the Athens-Clarke County Code. So thank you, and certainly I think we have a chance
There's a
for
3-minute
rebuttal.
following.
And if you have questions at that point or anything, I'm happy to try to answer them. But thank you for your attention to this. I know it can be a little tedious, and thanks for listening to me.
Thank you, Mr. Deloach. So of the array of opponents, I have Marilyn Vickers, Matthew Totten, and Richard McCormick. Are you able to distribute that time among yourselves, or do I need to allocate to you? All right. Good evening.
Good evening. Let me just see. My printer broke, so I have to read this off in order to keep to my time limit. I'm Marilyn Vickers, residing at 197 Witherspoon Court, Athens. I've spoken here before on more than one occasion about this particular property, always asking you to consider the community interest of residents over the individual property owner who is not a resident of Athens-Clarke County. So you probably know what I'm going to say. But I'm going to do a little diversion. Today is my son's birthday. He was born in Athens, grew up here, went to the Clarke County Public Schools. After serving 27 years in the military, active in reserve, he moved back here with his wife and 4 boys 2.5 years ago to begin a civilian career and to raise his boys in this community that had nurtured him and that he has always loved. His kids are going to the same schools he did, and he was able to find a house in the neighborhood where he had grown up and where I still live. He is part of the community that I see struggling some because housing for families is growing scarcer in part because of investment buying by non-residents who are not contributing to the everyday life of Athens. Now, this all relates because I'm going to have birthday dinner with the family after this meeting, but I thought it was important for me to come to this and once more to oppose a non-resident's request to make an exception to the decision already made by the Historic Preservation Commission, and I did attend that meeting as well. This, for a property that is still on the list of grandfathered in for STRs and not occupied by the owner. Now, the concern is that the HPC had given a permit for the requested construction only to have the petitioner flaunt the guidelines and build beyond the permit. A classic example of asking forgiveness rather than using the permission granted is what I see going on now. If the commission allows this, it could set a precedent for anyone else who wants to go beyond the bounds of the HPC and other ordinances that serve to protect our neighborhoods and the community we love. So I ask you to deny this request. Thank you for your consideration and for your service to Athens-Clarke County.
Thank you, Ms. Vickers. Mr. Totten or Mr. McCormick?
Hi, Mayor, Commissioners. Thank you so much for everything you do. I don't have a prepared statement, but I've been following this project since the very beginning. And I guess the first thing that comes to my mind was that this was all very avoidable. And I know the Williams did not intend for their house to be constructed outside of the parameters that were dictated. But the bottom line is it was, and their contractor made a mistake, I presume. And I think that's where the responsibility falls. I would also say that as someone who remodeled a home about 10 years ago, not in a historic neighborhood, but in a similar neighborhood, there were things that we wanted to do to our garage. For example, we wanted a a dormer that was a shed dormer. But the Planning Commission said, no, you have to have a conventional gable dormer. So we abided by that, and we built our house. You know, we didn't build a house and then after the fact want special dispensation for anything that might not have met the original parameters for the house. And in that same vein, I would say the Tottens who live next door were mentioned. Their home was built basically from the ground up, as was their detached garage. And in a historic district, they met all of the parameters. And so it's not a novel concept for a builder to build a house to whatever parameters are required by an HPC or a planning commission. So I'm here basically on the side of the HPC, and I feel like their unanimous decision was a valid one. Thank you.
Thank you, I appreciate it.
Good evening, y'all. My name is Matthew Totten. I am here for my parents, John and Susan Totten, who live at 440 Bloomfield. Just as a reminder, I'm sure most y'all remember that this existing COA was only approved before y'all the 5-4 vote. So even the existing plan was somewhat contentious. I did want to highlight, though, one inconsistency that Mr. Deloach pointed to in his letter. 440 Bloomfield is not 27 and a half feet tall. As some of y'all may remember, way back in 2014 when y'all were on the commission, the construction of 440 Bloomfield was very closely scrutinized, and it was ultimately signed off, constructed, and built at 25 feet tall. So I think that's important to look at in those relative numbers that Mr. Deloach was pointing to. And I think if y'all want to look at a picture or two that I think would really bring this to mind, if y'all haven't been out to the property recently, would be to look at the pages 69 and 70 of the overall packet, which were the pictures that the applicant included. And the aspect of that I really wanted to highlight on there is just the relative scale and how overpowering the garage is relative to 440 Bloomfield. Just to illustrate the scale here that we're looking at, the garage plus the exterior staircase is 32 feet wide. This is contrasted by the width of a primary residence at 440 Bloomfield of being 31 feet wide. So if you're trying to draw a direct analogy, this garage is bigger than a house that's adjoining to it. And while Mr. Deloach wants to point to the relative height of the garage to the primary residence, the real analysis that y'all need to look at is how it relates to the contributing historic structure at 120 West Cloverhurst. The guidelines touchstone on and on is how does an addition, an accessory structure relate to the primary structure, contributing structure in this instance, and whether it takes away, is more complicated, and overpowers. And I think we all would agree that that is the case here. Another point to really emphasize the scale and how overpowering this garage is and its massing is looking at it's approximately 10 feet closer to Bloomfield than the 440 Bloomfield residence is. So again, the size here is just wildly off. I did want to highlight, though, the staff report was very thorough and candidly, I think, addressed all the things that Mr. Deloach is saying weren't considered by the HPC. The one thing I believe the staff report did suggest that could be approved, and I would suggest that y'all's vote, if I was a commissioner, would be option 2, to uphold the HPC's decision while solely modifying and allowing the request to build the brick wall. I think everything beyond that fully touches on the scale, the massing, the size, the details that the HPC looked at. The other aspect I wanted to highlight is really going back to the touchstones of the guidelines. All these were talked about by the HPC. 4B.4 addresses the footprint of a structure in addition to in a historic district. And if you look at the illustration in 4B4, the example that they use is how a sprawling house, very similar to what this is that's proposed and being out there, is not in conformity with the footprint and the context of the historic district. I think that the HPC was spot on about that. 3F2, which the HPC also pointed to, it emphasizes that an accessory structure is to, quote, remain subordinate to the primary structure and, quote, respect the main structure in its overall height and dimensions. While Mr. Deloach is pointing to, well, you know, the drawing only said 24 feet, or 21 feet at one side, the drawing itself that was originally submitted represented was scaled. Scaled to the house, scaled everything. And as you all will see in that, it depicted, as a scaled drawing, that the garage would be no taller than the contributing historic structure. 3F4 within the design guidelines also addresses how an accessory structure should be less detailed than the main structure. And this is a point that the staff report in planning touched on, which addresses things like the brick skirting, things that are atypical and not seen, and certainly are more elaborate and detailed than what the contributing structure is. And then also 4B2, which addresses the sizing and the height of roofs. While we're talking about 4 feet here, which Mr. Matheny stipulated was the height difference, that's a 20% increase in the height versus what was proposed. Similarly, the roof pitch change is a 20% increase in the roof pitch. These are not casual mistakes here. It required more material, more sizing, different trussing. It's a situation where it blows past y'all's previously approved COA, and it needs to be revisited.
Thank you, Mr. Todd.
Thank you.
Mr. Deloach, would you like an opportunity for rebuttal?
I'll be very brief. Thank you, Mr. Mayor. Just with respect to the difference in height, I relied on the Traditions survey. We had a surveyor go out and do it. So the heights that I quoted in my letter were from a surveyor who went out and prepared the elevations. So that was the basis of that. I do think there's one important point. There's been discussion. This is not an accessory structure by the zoning guidelines. This is an addition to the existing house. And that distinction is a difference within the guidelines. And so the discussions about the guidelines for an accessory don't fit this. This is an addition to the home. And again, the expert that testified talked about scale. You can look at the photos, and no one today has referred to the fact that the HPC did not consider, there's been a lot of discussion on the height, but the HPC did not consider any of the other 3 elements that were part of this request. And so that by itself, the failure to even discuss those is an abuse of discretion to deny them. But again, the height being the thing that folks are certainly most concerned about, the height of the roof is 0.7 feet higher than shown on the plans on the north side. It is 3 feet higher on the south side. And the elevation is 4 feet higher than the house. Those are the absolute facts. But just because that's the case does not mean that it's not in conformity with the standards, and does not mean that a COA should not have been issued. In fact, we stand by what Professor Reap said. He was there voluntarily on his own as an expert in the area, and we believe that when you consider all things, failure to grant this at this stage would impose a substantial undue hardship on this property that is not appropriate. And again, that's we're going to leave it with you. We appreciate your consideration and thoughtfulness in hearing us in this appeal. So if there's any questions, I'm happy to answer them if I have time to do so. Otherwise, thank you.
Thank you. All right, now it's time for us to turn to action by the body. I'll entertain a motion from a member of the body.
Mayor, I'm going to make a motion, but I want to say some things first, if I could, so I appreciate it. You know, these hearings, Commissioner Wright and Mayor Gertz and I have seen several of them. And it's one of the ones, these type of hearings are one of the ones that, I don't know, for some reason they cause me a lot of angst. And just, you know, when people come to us and want us to talk about a decision a community group has made, be it over a window or garage or you know, railings or porches or something. And And they cause angst because, for me, they do, because there's always people that are asking us to do it or not do it, and they're good people. I respect everybody in this room on both sides. They have good opinions and their hearts are in the right place as far as making sure things are right for their neighborhood and for the community. And to say all that, to say I've driven by this house, I think 722 times, as tall as it is, just kind of getting a different perspective, looking at it. And I've had other people drive around there saying, hey, what do you think of this? And so forth. But you go back and you look at the evidence that was presented at the hearing, for the new, and which is why we're here, looking at what was decided about it with the HPC. I did read the transcripts. I read what Professor Reeps had to say at the hearing, and I respect Professor Reeps quite a bit as well. He knows his historic preservation stuff. I have his book by him. With all that to say, when I drive by there and the 722 times and look at it, I just remember when we have things like this come to us, we're always looking at the front of the house. And if you can see a structure from the front of the house, or if you don't see the structure from the front of the house, that kind of tells you which direction you need to go. This piece of property, unfortunately, is on a corner, but it's on a corner on a street that does have that elevation that goes up. So I say all that to say, I don't disagree with what Professor Reeps is saying, that it doesn't create a substantial sort of outlier from what's in the historic district. So I'm going to make a motion to accept the Planning Commission's recommendation, but to modify it to approve the request.
I'll second.
All right, got a motion from Commissioner Hamby and a second from Commissioner Wright.
And Mayor, I'll just add one thing, and I say all that to say, I wasn't supportive of it from the get-go, but it got approved and it got built, and it doesn't reflect to me, and to somebody like Professor Reeps as a substantial variant from the district.
And so I just want to make clear that kind of the motion would, in layperson's terms, accept the structure as built. Is that?
Except the petition that was presented at the Planning Commission. The last, at the HPC, I'm sorry. Except the petition for the
Accept the petitioner, property owner's request.
request.
Okay, all right.
And that covers the other details that were not discussed.
Right. Okay. Any follow-up as seconder? Commissioner Link?
Yeah, so when this came before us the first time on appeal from the neighbors who were appealing the plan that had been approved by the HPC, I was a little surprised that the HPC had approved the plan because I recognized that the massing was significantly larger than the existing historic structure, and they seem to be getting away with it because of the addition rather than accessory structure aspect of it. So I was one of those four in that 5-4 vote that voted to deny that appeal. And there's already been a heck of a lot of scrutiny on this property. I feel like as the construction moved forward, there should have been exceptional scrutiny in the construction phase to assure that it adhered to every single letter of that initial HPC approval. The fact that it hasn't, leads me to feel like this is one of those ask forgiveness rather than permission cases. So I would vote against approving this appeal. And I will point out it wouldn't be the first time that we've had a case like this. There was a case on DuBose Avenue in the historic Boulevard neighborhood about maybe a dozen years ago, where a petitioner was required to lower the roof line because of the same situation where you had a grade. I kind of feel like maybe we need to revisit our guidelines and consider those grades, but it was also very clear that it was substantially higher than what was approved, and it was a controversial property. There were quite a few folks from the neighborhood who came out addressing this massive scale of that addition. So I feel like this is a similar case. There was extreme scrutiny on this property. There should have been extreme care to adhere to the line and letter of what was approved. So I would vote to deny this appeal and stick with the HPC's decision on if
Any other input from the body before I return to Commissioner Hamby? Commissioner Taylor?
I agree with Commissioner Link. I feel like if we put these commissions together and we put these boards together, and the fact that you had guidelines and you went over it, to his point, it took extra material and it took extra work to go outside of what was approved. And I do believe that if we approve this, that we will set a precedent that, well, it's okay to just go over it a little bit, and then we'll appeal it. And then we'll appeal to the commission, and they'll approve it. And we'll get to the point where we just can't control it to where we will have to change the policy and I feel like we should stick to our guns. I feel like this body maneuvers from policy when it's beneficial to however long you've been on the commission, whose vote was a part of the original vote or whatever. When we have guidelines, I feel like we should stick to them. I do feel like this is a do it anyway and ask for forgiveness. There's a lot of that going on in Athens and in this government, and we just shouldn't keep allowing it openly. So I agree with Commissioner Ling. I will also be denying the request.
Any other before I return to Commissioner Hamby?
Sure, and
Commissioner?
I certainly appreciate y'all's thoughts and viewpoints on this, and don't totally disagree with them, but I came to a place where I was thinking, okay, and you brought up the point, well, how did they approve the first one? And it was big, and I was one of those 4 as well, but, and I was thinking in my mind about this one, well, if they were okay with that one, why are they not okay with this one? And so at any rate, I hope it doesn't set a precedent. I worry about sometimes when we do some things and other people do some things and overreach that's kind of setting the precedence, because it puts us in a bad spot, because we don't want to do anything that hurts future historic designated districts by going through a process like, people, you know how it is, Commissioner Link and Commissioner Wright, when we go through, people want to be or not be involved in a historic district, they always find examples to point to about why not to do it. So I don't know, y'all. I don't know what, but my motion's on the floor, so I appreciate your thoughts on it, though.
Commissioner Thorne?
I'm sitting here, I think this is really bigger than the historic district. I think it impacts everything that we do, and I've seen where we've made changes in other issues when and sometimes you have to make changes. I'm struggling with my vote. I guess I'll see where this goes, because this big and that big, I can't even imagine. You know what I mean? I'm just not there. But I do respect that the neighbors' concerns, and I also respect the rule on this one. I'm feeling a little bit torn. I know what I want to vote, and I think I know what I want to vote, but I do think that next month I just cannot see somebody coming back in saying, well, it's just this much, or it's just that much. So I'll when we vote, I'll see which way my hand goes up.
Thanks, Commissioner. And just as a legal note in terms of local government law, every zoning or related action is a standalone action. I know we sometimes feel there's almost like an emotional precedent, but legally speaking, every decision is made site-specific with the context of that site. So I've got Commissioner Wright now.
Okay. No,
Yeah, well, some additional details, now that we're in discussion mode. I found it interesting that the HPC didn't methodically discuss each of the asked elements of the certificate of occupancy. So I think that having it approved, we're helping those other elements move forward as well. But being new to historic districts in the last few years, the example that I ended up in my district and learning the front look of it. You don't go around back. We've had places that they're like, this window doesn't match, this door doesn't match the back door, it doesn't matter. We're working on the curbside appeal, the front of it. I think that because this property is on a corner and everybody does see the side of it, if it was in a row of houses, I don't think that we would be getting this scrutiny to it because, and again, it's the ground elevation. We've had other projects. There's a house on University that was measured, the way, the measurements that they made had a different result than what was expected on the floor plan. And I don't think it's malicious what has come about, and I do believe that it does fit in, and from the front of the house, you don't see this. And I thought that that was one of the main things for historic preservation, was that we were trying to help houses stay livable and stay occupied and being good neighborhood houses that fit in to the historic districts, and that's why I'm supporting that it can move ahead.
Commissioner Thornton.
So my next question is, and I guess I'm totally new with historic districts. I really thought this was a height issue. Am I wrong about that? Are we talking about something else?
You know, and certainly we have staff from planning here, but, and attorneys who staff the HBC, but I think the plainest read of this is it is a question of height because of the angle of the roof.
Okay, so all the other things that have been brought before us, really, we should discount from our decision-making? Like the wall, the size of the, all of that.
What will you provide? Thank you, I appreciate it, Attorney.
Sure, of course. So the application, and it's in your packet, but the application itself, actually in the defining its scope of work, only addresses the height. So the applicant only asked for consideration of the change in height. The brick wall, those other matters that have been mentioned, those actually all came, and planning staff is here, they could speak to it as well. Those came about upon staff. When staff went out to look at the property, they noticed those changes and included them in their own staff report. But technically, the application does not ask for HPC's consideration of those. And so I would limit your motion, whatever comes out of this body, to keep that in mind, what the application actually asked for.
And my next question is, and all of this is coming back to me, and I guess because I don't deal with it, but I do remember Mr. Tyler and all those nice people. So all of this is coming back to me. What is the next step? What happens if we, let me make sure I got the right group. If we deny the petitioner, the petitioners, so what options do they have? What options are out there?
Well, first, I guess just framing what your ability is, what you are approving and things like, just so we get the right words. So you're either voting to approve the HPC's determination, approve and modify that determination of the HPC, or you're rejecting the determination of the HPC.
The last one. What happened? What's the next step if we reject the HPC? What's the next steps, if any?
Sure. The applicant would have the opportunity to appeal that further to the Superior Court.
That's where I was trying to get to. Okay.
All right, everybody know where we are? We have a motion and a second on the floor. I'll go ahead and begin with the roll call with Commissioner Hamby.
Hamby,
Yes.
Link,
No.
Taylor,
No.
Wright,
Yes.
Fisher,
Yes.
Culpepper,
Yes.
Myers,
No.
and Thornton.
Yes.
Mayor, you have 5 yes, 3 no.
All right, motion carries. All right, thanks, everyone. I appreciate it. Entertain a motion to adjourn.
So moved.
All right, got a motion to adjourn from Commissioner Wright, second from Commissioner Fisher. All in favor, please say aye.
Aye.
Any opposed? All right, thank you, everybody. We have an executive session before we begin our regular voting monthly meeting.